Morning's docket, case number 115763, Timmy Glaze v. J.K. Williams LLC et al.
May it please the court, Daniel Smith, on behalf of the appellant and petitioner Timmy Glaze, we would request to reserve 5 minutes for rebuttal.
All right. Five minutes is granted.
Thank you, Your Honor. Mr. Chief Justice, members of this court, this case, from a procedural factual background, is fairly straightforward and presents a really narrow legal issue for the court's decision and consideration. In this instance, Mr. Glaze was working as a trucker and was injured. He thereafter filed an application for hearing with the Kansas Division of Workers' Compensation in December 2012. He was under medical treatment and he remained off work and was in fact determined to be disabled by Social Security during this time. In December or January of 2015 or January of 2016, the respondent employer filed an application for dismissal of the case pursuant to KSA 44-523-F1. The claimant, Mr. Glaze, the petitioner here, filed a motion with the ALJ setting forth facts which we believe to show just cause or good cause for granting extension of time to hear this case and bring it to regular hearing. As noted by the Court of Appeals in its decision at the time of the dismissal of this case by the ALJ in February of 2016, Mr. Glaze remained under medical treatment, not at maximum medical improvement, had not been dilatory in his pursuit of the case, and had not in fact
And when you say he was not dilatory, he actually, you and he had
we
actually...
were pursuing his case, yes.
You were pursuing the case.
And we had not abandoned it, as noted by the Court of Appeals in its decision at page 1.
And in fact, you were still awaiting information at the
That's
time
true.
this dismissal was filed.
Right. Part of our issue was one of the doctors we needed was somewhat unavailable to us, so we could not depose that person. Which brings us to this posture where the Court of Appeals affirmed the dismissal, and we are now here requesting the court's consideration of the proper interpretation and construction of the statute, in particular the third sentence of 44-523-F1. While I was preparing for this argument today, I had occasion to see a documentary by Ken Burns on Mark Twain. And of course, I was being somewhat dilatory myself, I suppose, and I thought about Mark Twain and what he might have said about what I was trying to accomplish here today. And I thought perhaps in his lighthearted, whimsical way, he might have said with the quip, "Let us be perfectly clear about ambiguity." Now, quite more seriously, Mr. Glaze is not a fictional character. He is, in fact, a man who has been disabled by work injury and is, in our estimation, has a valid, reasonable claim for compensation benefits under the Act. We contend that the third sentence of the statute, 44-523-F1, is ambiguous. Not surprisingly, the appellees claim that it is not ambiguous.
Where did the Court of Appeals go wrong? The Court of Appeals agreed with the appellee that it was not ambiguous.
Well, I'm glad you mentioned that, Justice Rosen, because it was rather remarkable, the sea change that took place between oral argument before that panel and their decision. At the time we argued this case, the author of the Court of Appeals opinion at least tacitly, if not overtly, acknowledged that the statute, in particular sentence 3, was ambiguous. And I felt that at least one other member of that panel agreed. One of the other members of that panel did not agree and didn't say anything, but we learned that he had decided the decision in Breedlove, which involved an earlier version of the statute. Now, we've set out in the brief, in the appendix, a comparison of the statute before its change and afterwards. And you can see that the original of that was very succinct and it was fairly draconian. It says, that shall be dismissed after 5 years. Whereas the new mechanism that was installed in 2011 with the statute's amendment to address due process concerns, provided for a hearing, and a variety of other safeguards. The argument that we have here today was actually presaged and by the comment by Justice Johnson in his recent decision in McCullough versus Wilson, 115667, which was released last Friday, in which Justice Johnson states on the issue of ambiguity in statutory construction at page 13 of his opinion, statutory provisions may be ambiguous, though the absence of uncertainty of the text. And he goes on to say at the next page on top 14, quote, even crystal clear language cannot always save a statutory provision from the specter of ambiguity. And that is in essence, the argument that we present here today. A time-worn illustration of that phenomenon is the classic road sign, slow men working. The 3 words are plain enough, although the plain words, their meaning is elusive. It is ambiguous whether the word slow is modifying the word men. This leads to a consideration of the reason for the sign. Is it designed to tell motorists that the workers on the crew are slackers? Or is it rather that the motorists should slow down, reduce their speed, because there are pedestrians in the area? Appellees complain that the deconstructing of the 3rd sentence, as we've done, somehow robs the language of its vitality. The interpretation and construction of the 3rd sentence is the task in the course of this case. Nothing more, nothing less. Deconstructing the sentence is the necessary process to determine its correct interpretation.
If we agree with you, you're getting close to running out of time. What is your best argument that
Our best
we
argument,
should, that legislative intent or legislative
before
history?
we get to legislative intent,
What's your best argument that we should find in your favor if it's ambiguous?
that the construction of the statute can be one of 2.
Right.
We propose a construction that says that if we diagram the sentence, we have the main clause followed by 2 dependents. And we say that the second dependent clause modifies the immediately preceding first clause rather than going back to the beginning main clause. And that makes more sense, and it fits with the statutory purpose, which is to get rid of stale claims. What we propose in our interpretation meets that same criteria. If we can present facts to the court before there is a dismissal of the case and show good cause, then we should be allowed an extension of time to proceed to regular hearing. And that is what we have asked for in this case.
And you don't have to rely solely on what the legislative intent was, because the actual language talks about a dismissal based on lack of prosecution. Later on, then, it says dismissed with prejudice by the administrative law judge for lack of prosecution. So the text itself sets up the criterion for dismissal, doesn't it? It's lack of prosecution.
That's the rationale behind it. I'm not certain myself that the legislature has been very artful about trying to do that, even though we can infer that that was their intent. And that's certainly what Welty said, was it's designed to get rid of stale claims. And I think the legislature rightly considered in making its amendments in 2011 that the knife cut too broadly when they initially enacted it, and wanted to carve that back by having this mandatory hearing at which evidence could be presented as to just cause. And as noted in the earlier argument, it didn't make much difference whether one had that written motion for extension either on day one after the filing of the application, or the day before the expiration of 3 years, or 2 days after the expiration. It was all fairly perfunctory as far as that's concerned. The issue is, was there good cause? And in this instance, the ALJ said because of their interpretation, which we think is erroneous, they never reached that. We never really had a consideration of the good cause, which is the reason we want to be remanded back to the ALJ in the division for that purpose of determining good cause and then proceeding to regular hearing.
Under your interpretation, whether there's a time limit or not, but let's just say that there isn't, and once the claimant has established good cause, can the employer then file another motion down the road, or what happens after there's a determination of good cause? Does it just go on indefinitely at that point, the case? If it's to get rid of stale claims, what happens after 2 or 3 years and nothing's happened once there's a finding of good cause?
Okay, I think the fair answer to that is that if after 2 or 3 years and you're still at a point where you can't resolve the case, then that case is still ongoing. The workers' compensation could go on for a lifetime, I suppose, in certain respects of a particular claimant. That's kind of the nature of the way it's set up. And so it would not be inconceivable that it could go on at some extended period of time. The question still remains, is the case being actively pursued, or do we have a bunch of stale cases that are sitting over here just accumulating dust? And our argument is that the way the statute's being construed is erroneous, and it cuts far too broadly for what the language says, and number two, for what the legislative intent clearly is, which is to merely get rid of stale claims and preserve those that are meritorious for adjudication.
I guess another way to ask that, does a claim ever become stale once the good cause is established to extend the time period?
No, sir. Not unless you depending on what the circumstances are. If the reason for good cause was the person had not reached maximum medical improvement, and for instance might be receiving temporary total compensation. If that condition remained after 2 to 3 years, well, you're probably going to run out of benefits anyway, because the time period that you can receive it uses up all the money available. But assuming that it continued on and the person 2 to 3 years afterwards was still not at maximum medical improvement, receiving temporary total, yes, you still have good cause for not getting to a regular hearing. Because, as we pointed out, a fundamental of adjudication in these cases is that you cannot go to a regular hearing until the person has reached maximum medical improvement, at which point they can be rated for a permanent condition. If they have not reached maximum medical improvement, they can't get to a regular hearing anyway. It's sort of like reminiscent of our adoption case. We can't ever get to that point. So yes.
That whole maximum medical improvement really isn't a part of the statute. Isn't it a regulatory Department of Labor consideration?
It states that terminology in the statute. And with practitioners in this area, it is a buzzword, if you will, which has been adopted, if nothing else, by common parlance, if you will. Okay. And so it has a distinct meaning, which generally is the person has been determined to be as medically improved as they could be, and there's no more medical treatment to be provided. Thank you.
I'd like to take you back to your claimed ambiguity for just a second. I know you're out of time, so hopefully this can be brief. my understanding is you're claiming the ambiguity arises because the third clause of the third sentence, in your view, could modify the second clause.
Yes, sir.
And so, at risk of offending the memory of my third grade grammar teacher to talk about grammar,
Eighth grade.
right? As I consult the grammatic authorities, my understanding of the second clause is that it's a non-restrictive clause, which is defined as a clause that's set off by either 2 commas or parentheses or em dashes, and which typically begins with the word which. And the authorities that I'm consulting suggest or say that when you have a non-restrictive clause, it can be removed entirely from the sentence without changing the essential meaning of the sentence.
My grammatical authorities say the same thing.
If that were true.
Doesn't that defeat your argument?
No,
is
it
the
does
question.
not. Actually, it goes the opposite. If you remove the second dependent clause.
No, he's not talking about what you're calling second. You're using different
Okay.
numbers, and that's confusing.
shall be-
Let's just call them 3 clauses. They're
All right.
not really, but just for purposes of simplicity. What you previously referred to as the second dependent clause is what my colleague has just referred to as the third clause.
Right.
The
Correct.
material that follows the second comma.
Correct.
And what he's suggesting is that because the material, the language between the 2 commas is introduced by the word which and contains information extraneous to the meaning of the sentence, it is a non-restrictive clause and it can be removed and the
Oh,
sentence is
okay.
complete without it.
I think I understand where you're coming from.
Which
And I
means
would-
that the
my
last
answer to
language
that
doesn't
is fairly
modify it.
succinct. And it says this. The first clause after the main clause, which is, I'm still.
The
on my-
material immediately after the first comma.
Yes, the material after the first comma is restrictive of the first one.
How do
It
you
is-
how do you get there when it's introduced by the word which and that phrase is enclosed in commas? Grammatically.
Grammatically, because the first clause, the main clause, says we have a broad grant of authority to do justice, if you will. And the first material we come to after the comma is putting a limit upon that broad grant of authority in the main clause. Because it's saying to the court, you may not dismiss a case under which these circumstances prevail. So it is a restrictive clause.
It helps define good cause.
Yes,
A partial definition of good cause.
yes, it gives an example of what is a presumptive safe harbor. And we're saying that the safe harbor is simply, is
It's giving an example.
is
And
created
it's-
and
so
that
it's-
the material that follows the second comma, the last part of the sentence, is modifying that safe harbor. The conditions for safe harbor.
I'm just
is-
suggesting in my question that the grammatical authorities say otherwise. And this is a case that frankly rises or falls on the existence of 1 comma, and it's the second comma. Because to get to the meaning that you desire, to be grammatically correct, again, as I read the authorities, that second comma would need to be removed. And so the meaning changes based on the existence or non-existence of that second comma.
And really,
So
it's
there's no ambiguity.
And actually, I would suggest to you it's a comma splice, because that last material is in contrast from what it said at the beginning. The intervening material between the first comma and the second comma says when you may not have discretion to dismiss. The material that the tag in is saying when you have discretion to dismiss, which is need to file within a certain period of time. I'm saying that it's more sensible to read that as a modification of the safe harbor. And I would agree, perhaps it doesn't follow exactly the grammatical rules, but it does, if you were diagramming the sentence, that last clause would more narrowly define, we would be drawing a line from the first dependent clause to be modified by the second one, rather than having it go leap over the intervening to get to the first. I just think that's a more sensible
Can I
construction.
inject something here?
Yes.
Do we have to guess at that? Because what we're calling the third clause, well, what we're calling the first clause says the administrative law judge may grant an extension for good cause shown. You go to the third, you don't have to guess because it said provided such motion to extend is filed. It's directly referencing it, isn't it?
The word motion, it first appears in that last clause. Up to that point in the statute, we don't talk about motions anywhere. And so it's not
So
clear
you're-
whether it's intended, that last clause is intended to modify the original main independent clause, or if it's intended to modify the intervening clause, the one that's between the first two commas.
So you're saying such motion, that language is in and of itself ambiguous because motion has never been mentioned.
And
prior
right,
to that.
and extension is never really defined, it just says extension. Well, it doesn't say extension of what, not ladders or whatever else. We assume it's an extension of time for, if we were to fill it all in, it's implicit, I suppose. It's an extension of time to bring the matter to regular hearing.
But if you're granting an extension, that assumes there's been a motion filed. Judge isn't going to sua sponte grant an extension.
It's a little unclear to me whether one is filing a motion in a written form or not. It says if the subsequent sentence in 4 says, if you can't show just cause after this hearing, I suppose, then it could be dismissed. Well, that depends on whether or not that, one conceivably, if we're in a Chapter 60 type case, you could come in and say, well, we haven't pursued our case for whatever kind of claim we might have had for a variety of reasons, and the court would be entitled to do justice and determine that the case should not be dismissed for lack of prosecution.
Well, Counselor, the employer files an application to dismiss. The court's required to set that application for hearing. Notify the claimant's attorney. If the claimant's attorney responds that the claimant has not reached maximum medical improvement, then do you have to also file a motion to extend, or can the administrative law judge may grant an extension for good cause shown if you've shown it through a response to the application?
The ALJ could extend the time. What we're saying, though, is that the safe harbor presumption precluding dismissal of the
Well, I'm
case.
not talking about that. I'm talking about how the safe harbor has to be raised. My colleague's saying, well, you have to have a motion before you can have the extension. And I'm saying if you automatically set a hearing and that fact is shown to the judge, why wouldn't the judge have the authority, once that information is placed before the court, to may grant an extension for good cause shown?
Well, that's our position, yes.
Why there has to be a motion to extend under that language.
We would certainly agree with that interpretation.
Do we have any further questions? Thank you, Counsel.
Thank you.
Thank you, and may it please the court, my name is Ryan Welts, and joining me today is trial counsel Chris McCurdy of the same firm, Wallace Saunders, on behalf of, excuse me, J.K. Williams and its workers' compensation insurance carrier. The Kansas Court of Appeals has arrived at the correct interpretation of KSA 44523F1. The procedure that is required in order to save a case from dismissal with prejudice is that the motion must be filed prior to the expiration of the 3 years from the date of the filing of the application for hearing. The timeline in this case is contained within the briefing, but I think it's important. that we started dealing with a 3-year as opposed to a 5-year statute effective May 15, 2011. In August 2011, Timmy Glaze sustained his work injury. He filed his application for hearing, the E1, on December 5th, 2012. And by doing that, Mr. Glaze was inviting the adjudication of his rights under the Kansas Workers' Compensation Act. And one provision of the Kansas Workers' Compensation Act was this KSA 44-523, and the court's familiar with that. With the E1 being filed on December 5th, 2012, he had 3 years to bring the matter either to a regular hearing or to have it settled or disposed of by way of an agreed award by December 5th, 2015. The case was not set for hearing, wasn't heard by then, wasn't settled by then, and no motion was filed prior to that date. That allows J.K. Williams, through counsel, to file the application for dismissal. 44-523-F1 provides that the employer shall be permitted to file with the division an application for dismissal based on the lack of prosecution.
What's the purpose of the hearing at that point? If it's automatic, if there hasn't been a motion for extension filed within the three-year period, why is there even an opportunity for a hearing? What's the point? What can the worker do at that point?
It's not clear to me other than there was an amendment to the statute.
Perhaps it's an opportunity to establish good cause, isn't it?
Well, we would argue that that's not. Because the only statutory vehicle for providing good cause or any reason that the case should not be dismissed is by way of a timely motion. Because of this third clause that we're talking about that says, provided such motion to extend is filed prior to the 3-year limitation provided for herein.
Counsel, even if that sentence, as some of us might say, is not ambiguous, that sentence standing alone, don't we have to look at the whole provision? And isn't there an internal inconsistency, as has been suggested by my colleague Justice Rosen? Why bother to have a hearing, particularly an automatic hearing, on a motion to dismiss if dismissal's automatic if the motion to extend has come too late?
I don't know.
So that's ambiguous, isn't it? The whole statute, when you read that whole section together, rather than just isolating the one sentence.
I'm not sure that would rise to the level of an ambiguity. I think that it's curious that there is a provision for an automatic hearing in this case or in any case where the motion wasn't timely filed, because according to that literal language, nothing can be said on the part of the defaulting party that can change anything. The court is not given any jurisdiction to do anything other than dismiss the case. The court does not have jurisdiction to hear any arguments and doesn't have discretion to not grant the application. But that's what the legislature gave us here is.
But we can't read. This automatic hearing, is I think what tips the balance over against you, and so we can't read that language out of the statute. And that's kind of what you're asking us to do. We can't figure out why it's there, so just forget about it. We can't do that because the legislature stuck it in here. And so it seems to me that, plus all this discussion about which clause and which is non-restrictive and all that, seems to tell me that this whole provision is ambiguous. I mean, so tell me why I'm wrong without reading that sentence about the automatic hearing out of the provision.
Well, the hearing can be held. There can be a hearing when there's a timely motion. There can be, and there's going to be a hearing when there's not a timely motion. The way we read the statute, and to propose the statute the way Justice Biles you're proposing, I think would make surplusage of that last clause, provided such motion to extend is filed prior to the expiration of the 3-year limit. The way we read the statute, I believe the way the Court of Appeals in its various iterations have interpreted the statute is that if within the 3 years the claimant files a motion that asserts that the claimant has failed to reach maximum medical improvement, then there's a statutory conclusive presumption that the deadline should be extended. Good cause exists in the statute outside of the allegation that the person has failed to reach maximum medical improvement for any other good cause that might be demonstrated. So if there were logistical issues with having the person prepare or arrive for independent medical examination or any other reasons other than the failure to reach maximum medical improvement, those could be timely asserted. So
the reason I don't think that the language about it being conclusive if you do file a request for extension within 3 years is because I see this provision operating as trying to clear out the dockets. So you're going to force the other side. You're going to file the employer's motion to get rid of this case, and you're going to automatically set it for hearing. And that means the other side has got to do something. They've either got to file a motion or they lose. And that makes that hearing part of the due process of getting rid of the case, as opposed to they don't do anything and all of a sudden they're thrown out of their rights for this administrative proceeding. So tell me why that's wrong.
Well, the due process argument is one that we argued in front of the Court of Appeals, and it was part of the petition for review up to this court, and the court didn't grant it. But the Court of Appeals handling of the due process arguments in this case below, I think are helpful for that, because it discusses that although that hearing doesn't provide any meaningful opportunity to raise good cause or to assert that an individual has failed to reach maximum medical improvement because those arguments weren't timely filed, that the statute itself does provide for procedural and substantive due process to injured workers, provided they file the motion that they're required to. So there are numerous places in the Workers' Compensation Act where an otherwise compensable claim may be ultimately found to be non-compensable. There are other default provisions under the Act, and we have hearings where those are asserted, and so that's what happens.
Are there any other provisions in the Workers' Comp Act where the parties are required to show up for something where the result is automatic?
I certainly feel that way sometimes when I'm walking into work. I don't think the statute has any other provisions where you have a hearing where the court has no jurisdiction to do anything other than dismiss it. I think that would be unique here.
That's not always the case under this statutory language, is it?
It's not always the case, no, because
so there could be a real. The language contemplates a hearing that is not illusory.
I think that you're correct, Justice Stiegel. And Mr. Cuban mentioned it in the previous oral argument that we do have individuals who file the application to extend the 44-523F deadline well before the 3 years. Sometimes they do it with the initial filing.
The non-illusory kind of hearing would be the one where the employer, after the expiration of the 3 years, files a motion to dismiss, but prior to that, there had already been a motion to extend put on file.
I would agree that would be a circumstance where the hearing here would not be a matter of statutory surplusage, that it makes sense that you would have that hearing because there may not always be an agreement as to whether an individual has reached maximum medical improvement. One of the most frequent things that we litigate in workers' compensation is whether an individual requires and is entitled to more treatment. So,
but what happens here is that in Mr. Glaze's case is that he hasn't reached maximum medical improvement. He's on his way to demonstrating that, and his claim is dismissed. He doesn't have an opportunity to show that.
Well, Mr. Glaze would have had the opportunity to demonstrate that had a motion been filed prior to the expiration of that 3 years. He would have been equipped with a statutory conclusive presumption that his case could not be dismissed under these reasons.
Wasn't part of the purpose of these amendments to address issues both for the employer and the employee, and not to have harsh results. And sometimes the mandatory cutoff at 5 years resulted in harsh results, and this provides a mechanism for not that to happen. And how is that objective achieved in this scenario?
Well, I think that this actually did represent a fair balancing of those concerns, that there wasn't an automatic dismissal, because without
there was an automatic dismissal.
Well, prior to 2006, there was no statutory mechanism to get rid of these claims, and then in 2006
Right.
they enacted
And then
one.
they had the 5-year cutoff.
Correct.
Regardless of what happened.
But doing it this way, I think it balances it, because it doesn't require the division to take it upon itself to dismiss claims. It has to be done on someone's motion. We representing employers are not allowed to file that motion until those 3 years have passed. So if a timely motion is filed before 3 years, we are 100% toothless to do anything about that deadline getting extended if they are able to demonstrate that the claimant has failed to reach maximum medical improvement or for other good cause shown. But claimants have to be vigilant. And if that 3 years pass without that saving motion being filed, then maybe nothing happens. Perhaps the employer and the insurance carrier don't notice it, or they elect to overlook it. But in this case, the statute gave us the right to file the application for dismissal.
Doesn't the statute contemplate this timeline? Claimant files, because you can't file simultaneously. Claimant has to file before 3 years, and then employer has to file after 3 years, and then hearing. Isn't that the timeline?
I
Claimant
believe
files
so.
for extension, employer files to dismiss, hearing.
I believe so, Justice Stiegel, but in my practice, a lot of times, particularly when the motion to extend is filed very early in the case, when there's no question that the individual is at maximum medical improvement, there's really no opportunity for...
Well, it doesn't matter. For purposes of my question, it doesn't matter when within those 3 years the motion to extend is filed. I'm just saying there's no other sequence. That sequence is locked in. The sequence is claimant files, employer files, hearing. There's no other possible sequence, is there?
I agree with you there, Justice Stiegel. Is the application for dismissal is the statutory possession of the employer, and it cannot be filed before 3 years. And the motion to extend belongs by statute to the injured worker, and that cannot be filed after 3 years. So that must be the sequence.
You could have a hearing on the motion to extend before the 3 years expires.
Absolutely.
Yeah.
If in this case...
But other than that, the sequence described by my colleague is mandated by the statute.
I agree, Justice Beyer. If in this case, if Mr. Glaze had caused to be filed a motion asserting that he had failed to reach maximum medical improvement, or that he had encountered difficulty because he lived out of state, then we could have come in and we could have argued he is at maximum medical improvement. This case has proceeded to a pre-hearing settlement conference, and there were some lapses in this case. We had to file a motion to compel the attendance at an independent medical examination. So we would have had arguments, and if the interpretation of this statute is out of this court different than what the Court of Appeals below has done, then I believe everybody has proposed the remedy is that we go and we have the hearing on whether there was just cause for the deadline to be extended.
Here's I'd like to back up for just a second. I mean, the essence of your opponent's position is that sentence is ambiguous, or that sentence means X, and you're saying, well, it doesn't mean what he says, and the statute's not ambiguous in our favor. Let's just assume for a moment that we're going to read it as a whole and that it's ambiguous. Then we have to go to things like legislative intent. Why does the legislative intent favor your position?
Because the legislative intent, and I appreciate the questions, Justice Beyer, because we've not gotten into any of the legislative intent yet.
No, and I'd kind of like to know what the answers are.
And so, from the previous oral argument, I think that we had established that the legislative intent in 2006, where this came from nothing, was to purge the system of old claims. And we would propose it did that. So we're not really looking at the legislative intent of what the legislature did in 2006. I think it's important to look at what the legislature did in 2011, which is left that operative language for dismissal be and shortened the time period from 5 to 3 years. That to me is a signpost from the legislature that they are looking to dismiss more claims as opposed to fewer. That would be the natural result of shortening that deadline. So we think that the legislative intent would certainly be indicative of a statutory scheme that overall became more restrictive.
Except for the other sentence about the automatic hearing. That's the problem, is that you have what looks like it was a legislative, it was an adoption of a compromise, in essence, between business and labor. And
Well-
it resulted in a statute that is kind of like the Scarecrow and the Wizard of Oz. You can go that way or that way, right?
And the justice is well versed on how we got this version of the 2011 Act, which is that practitioners from both sides got together, proposed something, and the legislature put it together. So I think that what we're left with respect to the hearing makes absolute sense when the motion is filed timely. When the motion is not filed timely, it's something that makes less sense to have. But I think ultimately what the Court of Appeals said on all of this was that the statute is inartfully drafted, but it's not ambiguous.
Any question, Judge Mott?
Well, I feel funny asking this after, because I'm a district court judge, and I've never done any workman's comp. So do you have e-filing like we have now?
We are
Because I asked, is it not e-filing or?
no, they're in the process of doing that, but at all times
I'm
this
just
is
coming off of here, and this is similar to me to a statute of limitations, and I just came off a big hearing. I ruled on it, whether something was considered filed or not, because it was filed and rejected. I ended up finding under the rules it was filed, right or wrong. But we were arguing about whether there was extraordinary circumstances to excuse a late filing and all those sorts of things.
Mm-hmm.
So I was just curious if any of that was something that was a play in the workman's comp arena.
There's not any electronic filing, and I don't think there's ever been any allegation that there were any exceptional circumstances that would forgive any of that. And I don't know. I think it's funny that the unusual circumstances or exceptional circumstances doctrine might get brought up.
Right. Well,
because
everybody was talking about how this is just a pro forma, and I had a hearing that was anything but, and it strikes me as similar to this. So.
Yeah, I'm just reminded that I was involved in a case where the unusual circumstances or unique circumstances doctrine was essentially overturned by this court almost exactly 7 years ago today. And what the court said in that was, these equitable reasons, they're all well and good, but they do not get you around jurisdictional deadlines. Those
right.
are
Well,
deadlines.
the clerk in our case had rejected because of some punctuation.
Yeah, there was no effort unless Mr. Smith wants to correct me on this. I don't think the record here today would support the idea that there was an attempt to file the motion that for some reason was lost in the mail or
I'm
was not
suggesting is there a
processed.
reason for this automatic hearing outside of what we're seeing? I'm just asking.
Yeah, I mean, I suppose that in one way that could be a safety net for the court to address whether there were any types of issues with a failed filing or something like that. But we do not have electronic filing at this time at all of the times relevant for the dates that these documents were received by the division.
Do you have any further questions? Do you need any 30 seconds to wrap up? Do you think you've made your points?
I believe I have, Justice Nuss, and I want to thank the court for entertaining us today.
Thank you.
Do I still have 5 minutes?
You still have 5 minutes.
I won't use all 5 minutes, but I just don't want to talk out of turn. My parting comments for you are that the construction by the Court of Appeals renders the hearing process an empty exercise in futility, as has been noted previously. The lower court's opinion erroneously rewrites the statute to provide that a hearing will be held on the issue of whether to dismiss only if the claimant has first filed a written request for an extension within 3 years. The language in the statute clearly does not make that statement. The appellant's construction of the language, which allows for the request for additional time at any time before the hearing, in this case, still permits us to be within the ambit of the plain language of the statutory provision. Moreover, this reading of the language avoids harsh results and comports with the legislative intent of the revised version of 523F1.
Which is what? Follow up on Justice Byers'
This
question
is back to the
counsel. What's
Weldy
the
decision,
legislative
which says the
intent?
purpose of this statute in its original form was to get rid of stale claims. Stale claims, not old claims. Old claims could be the one we discussed on the original argument about the person could be under not reach maximum medical improvement for any extended period of time. But what was the case here is that it gets rid of stale claims. Stale claims are ones that aren't going anywhere. Either the person's died, the attorney gave up, got tired, or whatever the case may be, determined that they didn't have a job injury, or whatever the case may be. It is to clear out all of the trash that may have accumulated over a period of time. And what has happened is that the legislature came back with the 2011 amendments with that hearing provision to try to strike a more even balance between getting rid of non-meritorious stale claims and allowing those which are meritorious and has good cause to go ahead and get to a hearing at some point rather than dismiss them. And we believe that our construction of the statute more nearly comports with that legislative intent. Thank you.
Do we have any more questions? Thank you, counsel.
Thank you, sir.
I thank both counsel for your arguments this morning. Court will take this matter under advisement.